Thank you. Okay, so thank you so much for bearing with me. It's the last presentation of the day. I know it's Friday, so let's just get through this and we'll all go have a great weekend. So I'm going to end the day with talking about two programs that are new or soon to be implemented here in Nebraska. And these two programs aim for the older youth in the system and help them have a successful transition to adulthood. I know Deanna Brinkage is here from HHS, and she is in charge, if you just want to wave. She's in charge of implementing the Bridge to Independence program, so any HHS-directed questions, she is more than happy to answer for you. So Bridge to Independence is a program that aims to help young adults or youth in the foster care system transition to a successful adulthood. We're not talking about transitioning just out of the system. We really want to make sure these young adults have a successful start to their adulthood. This started with LB 216, but it actually started before that with the Federal Fostering Connections Act of 2008, and that allows states to draw down 4E funding for youth through age 21. And what LB 216 and now the Bridge to Independence program does is there's three main parts to this. The first is that it extends services and support to foster care youth through age 21. The other two programs are extending adoption subsidies and extending guardianship subsidies. So for the foster care youth, there are three eligibility requirements. The first is a 3A adjudication. Now, the language of the statute isn't clear on whether this is a current 3A case or if there was a 3A adjudication at some point. Right now, HHS is interpreting this as a current 3A adjudication. The second requirement is in a foster care placement or release to independent living at age 19. And the third is fulfilling one of these education and work requirements. There are 5 different ones. The first is that they are completing secondary education. They could also be completing post-secondary education, and this is at least half-time. They also could be working for at least 80 hours a week, and this could be more than one job. So if they have several part-time jobs, they could, as long as they're working at least 80 hours per week. Month, wow. I was just studying for the bar. That was 80 hours a week. So sorry about that. They could also be participating in a program to relieve barriers to work or education, or if they have a medical or developmental condition that means they cannot do any of those above, that will fulfill this requirement as well. So the extended services are quite broad. The first is medical care. Now, the vast majority of youth for this program will receive Medicaid, either because they are 4E eligible or through the Affordable Care Act, which I will talk about just in a minute. They also will be eligible to receive continued foster care maintenance payments. Now, these can go to, if they're staying in the foster family, they can be for that. They can also be for supervised independent living, such as in a college dorm, or if it is medically necessary, it could be in a group home or other type of institution. There are also case management services available. Now, these really are broad, and they range from helping the young adult maintain relationships that they established when they were younger, to applying for post-secondary education or aid, or government aid, or to applying for courts for necessary documents for immigration relief. Pretty much anything you can think of that could help these young adults become a successful adult, that will fall within these case management services. To obtain services, the adults will have to sign a voluntary services and support agreement. Now, this program is completely voluntary. There are no requirements that young adults have to participate. They can opt in and opt out at any time between age 19 and 21. So if they begin the program, decide it's not for them, they are free to leave at any time. And also the young adults or the youth have to be provided with information starting at age 16 and then at least once a year thereafter. So this is something that courts can start to ensure happens starting at age 16. If there are these annual permanency reviews, it might be a good idea to start making sure at that point that these youth are hearing about this program and know what's available to them. So the court, like I just mentioned, the court can play a role not only in providing information, but there is, once the voluntary service and support agreement is signed, the court does come in. The first thing is to open a Bridge to Independence file. So it's a new file on the young adult. It is not just extending their juvenile court file. It's a brand new file. The court must also review the voluntary services and support agreement and make a best interest determination. And also there are annual age-appropriate permanency reviews. Now, the statute says annual or more often at the young adult's request. This is only as frequent as reasonably practicable. So this cannot be occurring once a week or anything like that. But if the young adult does feel that they would benefit from more frequent reviews, they can request. And these should be more informal and age-appropriate. So they will look very different from a review hearing for a 3A case. We're dealing with young adults, so we do want to make sure they are more engaged and more a part of the system than it would be if they are younger. Also, young adults can request to have a client-directed attorney. This is different from a GAL. Now, the GAL can remain and stay with the child, but with the young adult's consent, but it is in a completely different role. Unlike a GAL, who is for the best interest of the child, this is now a client-directed relationship. We are treating the young adult like a young adult because they are one, and so this is a completely different type of relationship. Also part of the system is case reviews, and these occur at least once every six months, or the young adult can request more frequently. And these are a collaborative process between the young adult and the foster care review office. Also, the young adult can request to have additional support persons there if needed. This is an informal collaborative process. Again, it's not the same thing as just a review hearing. The young adult is part of this and should drive what happens at these meetings. The second part of this program is adoption assistance, and these are for youth who are adopted at age 16 or older, and they also are meeting one of those 5 education or work requirements. These receive extended adoption subsidies and Medicaid up to age 21. The third part is extended guardianship assistance. This is a little bit more complicated because there are 2 different parts to this. One is an entitlement program. For young adults who enter a guardianship agreement at age 16 or older with a licensed relative, they are and also are completing one of those 5 education or work requirements. They are entitled to receive extended guardianship assistance and Medicaid to age 21. So that's easy. They are entitled to, every young adult who satisfies those requirements is entitled to that assistance. However, those young adults who enter a guardianship agreement at age 16 or older with someone who is not a licensed relative, there is a pot of funds that are set aside for those young adults to receive extended guardianship assistance. This is not the same thing, and so once these funds run out, that's it. I know the department is confident that they will be able to help all the young adults who need it right now, but at some point those funds will run out.
Question?
Yeah.
I just have a question about guardianship agreement. What's the difference between a guardianship agreement and a juvenile court-ordered guardianship?
It's the same thing.
Okay, so any child that entered a guardianship at age 15 or younger won't be eligible?
For this, no. Any other questions right now?
What about those kids? You're just gonna leave them out there?
Especially siblings.
Yeah.
One's 16, one's 15.
Deanna, do you know anything, if there's any plans to provide assistance for those kids? Okay. Yeah, so Deanne just said right now there's currently no plans to write legislation or help those kids who are under the age of 16 when they enter a guardianship.
But I can say for those individuals that entered into a guardianship, if they were in foster care, they can, once they are age 14 and older, they can be referred to Project Everlasting Expansion, which has those whole array of services in each community. So they are eligible for those types of services. They just won't get a financial stipend at age 19.
Yes.
I actually know Senator Crawford's office is looking into this issue to see whether or not further legislation is going to be needed to address
Oh, good.
those kids. So I would say if you have comments on that, we can help them contact her office.
So Senator Crawford, you said?
Yes.
So those of you who didn't hear, Senator Crawford is considering whether legislation will be needed to address that issue. So any comments or questions can be addressed to her. Thank you. Any other questions at this point? Oh. So for Bridge to Independence, what to know, just a few brief things. I've already discussed most of these, but just to highlight, For caseworkers starting at age 16, these youth must be informed of the program and then every year thereafter, and again, the court can also play a role in this. For attorneys, if a young adult does request an attorney, they shall be appointed one. And like I mentioned before, it can be the same attorney as the GAL, but the relationship looks very, very different. It's a client-directed relationship. Also for the court does have to open a new file, a new Bridge to Independence file for each youth that enters one of these voluntary agreements. And also the annual permanency reviews, which will look very different from permanency reviews on a 3A youth. Okay, switching gears a little bit to the Affordable Care Act. Now this is very complicated, so I included the language of the statute for you. And what this did is it created a new mandatory Medicaid coverage that the Act calls former foster care child. There are 4 requirements for a youth to fall to get in this mandatory area of coverage. If they are under 26 years of age, they are not otherwise eligible or enrolled in Medicaid, they were in foster care on the date of attaining 18 years or a higher age as set by state, and I'm going to break that one down in just a second, and they were enrolled in Medicaid when they were under the responsibility of the state. Now, there is no income test for this. So this means that no matter what the young adult makes as part of their income, they are still eligible. This also means that even if the young adult has private insurance through either their employer or through another means, they can get Medicaid as a secondary payer. So it doesn't matter if they can afford their own insurance, they can still be covered under this category, which is very important because, as we know in Nebraska, they did not get the optional Medicaid expansion. So this could be the only way some youth are eligible for Medicaid. So that third prong is the one that's probably going to cause a lot of problems for people. And just to break it down, the first part is they must have been in foster care. This is federally defined as 24-hour substitute care for children placed away from parents or guardians. So that's fairly simple, but however, it does not include guardianship. So this means for young adults who are placed in for youth who are placed in a guardianship, they would not be eligible for the Medicaid under this under this new category. It also does not include adoption. The second requirement is under the responsibility of the state. Right now, it's optional for states to cover young adults who were in foster care in a different state. Nebraska is choosing not to. I think right now there are 12 states who do cover youth who are in foster care in a different state, but it's up to the individual state. The third requirement is on the date of attaining. This means it's a point-in-time test. So the youth must have been in foster care on their birthday. So it doesn't matter if they were in foster care a week before, it's really on their birthday that matters for terms of this Medicaid category. The last requirement is on age 18 or such higher age as the state so chooses. Right now, HHS is interpreting this as 19 here in Nebraska because 19 is the age of majority. There's some debate about how that's going to work out, if it's age 19 or age 18, depending on the language of the statute. But right now, it really is just age 19, so it depends on that 19th birthday. Yes?
So I'm gathering if you are in independent living, as you age out of the system, you're not eligible.
Deanna, do you know anything? Do you want to answer that? The question was, if you are in independent living on age 19, would you be eligible?
At this time,
As you age out.
I'm not Medicaid, but at this time, it's my understanding that yes, they are. However, the federal government has not clarified if independent living is an out-of-home placement or 24/7, so that may change.
So the answer was the federal government has not clarified whether independent living qualifies as an out-of-home placement, but right now we're hoping yes, it does count. So a few things just to know. Again, because the Medicaid, the language is a point-in-time test, there's a big danger in closing the case even a couple days early. So really make sure that if you have a youth who their case could be eligible to be closed, but getting insurance would be a worry for them, keep it open until their birthday, until their 19th birthday. The second one is guardianship. If you're dealing with an older youth and you're considering a guardianship agreement, at least consider the Medicaid implications. If this would be the only way they're eligible for insurance once they age out, you might want to consider what that would mean if they enter a guardianship agreement. The last is the potential effect of moving. As I mentioned, it's up to individual states whether or not they include kids from other states. And so you might want to consider talking with young adults that you work with and saying, hey, before you move to this state, at least check into it because this is a huge deal and this would be really helpful for a lot of young adults. So because this is a pretty complicated area and because it's so new, we don't really know how a lot of these things are going to shake out. There are a ton of great resources out there. The CIP and Nebraska Appleseed have created a Bridge to Independence youth court form, very similar to the youth court forms we discussed earlier today, but this is for young adults in the Bridge to Independence program. That will be available online. It's not quite yet, but I do believe Nebraska Appleseed has a PDF copy on their website currently. Nebraska Appleseed also has some great resources, both for judges, attorneys, and also for young adults. So if you do work with this population, it might be helpful to go check that out, figure out what the pitfalls are, what are the dangers, and just be prepared because there's a lot going on in this area. Are there any other questions before I end? Okay, thank you very much.